Thank you, Madam Speaker. I'd like to thank the Honourable Member for this question. Madam Speaker, when Sitimani Rabuka carried out the first two coups in 1987, the head of the state, who was the Queen, was actually removed. And it unilaterally declared a republic. And therefore, there was a decree that was passed in 1989 to amend crown to state, because we no longer could hold the crown as the head of the state, so therefore it became state land. And therefore, the definition was changed from crown grant to state grant. State grants, Madam Speaker, is defined under the Land Transfer Act as any grant of land by the state. So where the state actually grants the land to somebody. The effect of a state grant is that the state grant give the land to somebody who then holds the title as what we call fee simple, or freehold title. Let me read the relevant section of the State Lands Act. Subject to the provision of the Constitution of the Republic of Fiji and any written law, the Minister, after consultation with Cabinet, may, and on behalf of the state, sell portions of state land and make and execute under the public seal of Fiji grants in fee simple thereof. So, for example, Madam Speaker, when the SDL government converted the Momi land, it was converted from Itauke land to Crown, then they gave it as a conversion to become freehold land. Because only the Crown can do that in those days, now obviously the state can only do that. So the state was able to, because it became from Itauke to state land, then they could actually transfer that land in fee simple, which meaning it became completely freehold, therefore they hold the land in perpetuity. That's what actually it means, Madam Speaker. So I assume that's the extent of the question the Honourable Member once asked. Under the Fijian Constitution, the 2013 Constitution, which I'll read to you, Madam Speaker, it says that any land occupied, any Itauke land acquired by the state for a public purpose after the commencement of this Constitution, under Section 27 or under any written law, shall revert to the customary owners. Shall means it must. In law, it means must. Shall revert to the customary owners if the land is no longer required by the state. So today we have in law, constitutionally speaking also, and as we know that the Constitution overrides any other written law, that any land, Itauke land, that's used by the state for any public purpose, so as we've given examples in this Parliament before, for example, if the state acquires a hill to put up a water reservoir, and it's for that public purpose to provide water to maybe thousands of people, if the state after a period of time then decides that they no longer require that land for the purpose of having a reservoir, they cannot hold on to the land. They must give the land back to the Itauke landowners. So that's how you have the reversion, which is now guaranteed under the Fijian Constitution.